So, Madam Clerk, you granted your approval. Okay, Ms. Simon, please. All right. Let the record reflect that Ms. Simon is present with her counsel and that the attorneys for the state are present as well as Detective Lemons. Anything we need to take up before we bring in the jury?
No, Your Honor.
Thank you.
No, Your Honor.
All right, very well. Please bring in the jurors.
Jurors entering. Jury room's clear, Your Honor.
Thank you very much, Smith. And good afternoon, ladies and gentlemen. Please have a seat. The day is beautiful. I'm glad you had an opportunity to experience a little bit of that. I want to ask, has everyone been able to comply with the court's instructions? Yes. No one has spoken with anyone about the case, discussed the case, or had any done any research? No. Okay. All right. Madam Parker, Ms. Parker.
Your Honor, the state would call our next witness, Dr. Darisaw.
The evidence you shall give the court and jury in the trial of this issue should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Good afternoon.
Good afternoon.
Doctor, will you tell the jury who you are and where you work, please?
Absolutely. My name is Laura, Lora, Darisaw, Darrrisaw. I work for the Georgia Bureau of Investigation, the GBI.
And what do you do at the GBI?
I'm a medical examiner at the GBI.
Will you tell the jury a little bit about your background, your education, your training to be a medical examiner?
Yes, ma'am. I received my Bachelor of Science degree in Electrical Engineering from Marquette University in Milwaukee, Wisconsin. I then received my medical doctorate degree from the Medical College of Wisconsin. Following that, I did 4 years of residency training in pathology at the hospitals of the Medical College of Wisconsin, which trained me to be a general pathologist. And then I did specialty training in pediatric pathology at Baylor College of Medicine in Houston, Texas. And that was a 2-year fellowship. And then I did 1 year of specialty training in forensic pathology, and that was at the GBI through the Medical College of Georgia.
And how long have you been a medical examiner with the GBI?
Since 2004.
So about 20 years.
Yes.
Your Honor, the state would tender Dr. Darisaw as an expert in forensic pathology at this time.
I'm familiar with Dr. Darisaw, so there's no objection.
All right, the witness is so qualified.
Thank you, Your Honor.
And actually, I think it was 2002. I'm sorry. Yeah.
Oh,
2002.
22 years.
Yes.
All right. Can you explain to the jury just briefly what the duties of a medical examiner are?
So yeah, primarily the duties of a medical examiner are to examine people who have died in certain circumstances. Generally, the circumstances are that individual has died suddenly and unexpectedly, or has died from unnatural type events such as traumatic events. And the purpose of the role of the medical examiner is to determine the cause and manner of death by doing an autopsy.
Tell them also what an autopsy is, since you mentioned that.
So an autopsy is an examination of a person who's died. There's 2 major components to the autopsy. The first component is the external examination. The external examination is very similar to the type of examination that we get when we go to the doctor as live people. We get our height and weight taken. The doctor examines our external body, and that's what the pathologist does. And then in an autopsy, there's also an internal component. And with the internal examination, the body is cut in such a manner as to remove the organs that are in the body cavities to evaluate those organs. And then, like I said, the purpose of doing the external and internal is to determine the cause of death and then a manner of death.
Okay. And when you do an autopsy, what sort of clues are you looking for that can tell you the cause and manner of death? I realize that's a long list, but could you just give us some examples?
Yeah, sure. Briefly, so to even begin an autopsy, we begin with information about the death, the circumstances of the death. And that is the same as when we go to the doctor. We have to tell the doctor why we're there. We have certain symptoms. There's a reason for us to be there. And that's the same with an autopsy. There's always some degree of information of the circumstances of the individual's death that we have to start with. Some of those circumstances are obvious in terms of the cause of death. We know that a person has gotten shot, and so it's kind of obvious that they died of potentially a gunshot wound. And in that instance, the autopsy documents the wounds, provides vital information for court purposes in terms of getting the bullet, for instance. In some instances, a person may die in bed, and we get information from family members about their history, and then that may give us clues as to why they died. So we always have to start with some pieces of information concerning the circumstances of that death.
All right. And is looking at someone's medical history a normal part of performing an autopsy to see what sort of health they were in?
That's correct.
Moving to this specific case involving 20-month-old Quentin Simon, after remains were found in this case, do you recall being consulted by members of the district attorney's office?
Yes, I do.
Okay, and did they come and meet with you and show you photographs of what there was
That's
as far as
correct.
remains?
Yes.
Okay. And then, are you aware that those remains went to the FBI,
Yes, ma'am, I am.
to a forensic anthropologist?
That's correct.
Okay. After the FBI was done, were the remains sent to your office?
Yes, following the FBI examination of the skeletal remains of this child, I did receive those skeletal remains, and my examination was limited because the FBI was primarily involved as anthropologists, and I'm not an anthropologist. So my involvement in terms of evaluating the skeletal remains was inventorying the bones that we received.
Okay. Now, in a situation where the remains are primarily bones, would you be able to perform an autopsy?
No, not in the sense of obviously what I've just described to you as a complete autopsy on an individual who, let's say, is an intact body. So when there's only bones, it's going to be very limited ability to be able to provide enough information to say how a person has died.
Okay. And so is it normal in the situation where the remains are basically bones for a forensic anthropologist to be consulted?
Yes.
I would like to talk to you about one specific potential cause of death, and that is what is commonly known as sudden infant death syndrome, or SIDS, as people here call it. What is the medical term for that?
So SIDS is Sudden Infant Death Syndrome. That's the acronym for SIDS. And SIDS is a definition of a death. It's not anything that one finds in a child. So it's a very strict definition. SIDS is defined as a death in a child who's 1 year old or less, whereby the autopsy doesn't identify any specific cause of death. The autopsy doesn't identify an infectious disease process or trauma. So we call these negative autopsies. And so the autopsy is negative. In addition to that, the definition of SIDS also requires that the investigative information doesn't reveal any suspicious circumstances surrounding the death, or the investigation doesn't reveal any, for instance, in a sleep environment, not an unsafe sleep environment that may cause a child to asphyxiate or suffocate. So it's very strictly defined as being a negative autopsy in a certain age, 1 year old or less, and no suspicious circumstances.
Okay. So a 20-month-old child would be too old to fall under the definition of SIDS.
That's correct.
Give me just 1 minute. Just to go a little bit further regarding the skeletal remains, in this specific case, you were not able to perform any of your duties beyond just doing an inventory of the bones. Is that correct?
That's correct.
Okay. And in this case, this wasn't just like remains found lying out somewhere. They had actually been in a landfill and had damage done to the bones.
Correct. Subjected to, environmental damage as a result of being in the landfill.
That's all the questions I have. Thank you.
Good afternoon, Dr. Driscoll. How are you?
I'm good. Good afternoon.
So when you received the remains, you weren't able to conduct the normal autopsy, so you couldn't remove any of the organs or tissues or anything like that because you just didn't have them.
Correct.
And if I'm understanding correctly, did you receive any tissue samples, or was it just the bones you received?
So in the inventory, everything came to us from the GBI, packaged in bags and multiple bags. Mostly everything was bones. There was small material that could not be definitively identified as organs or skin, but there was some degree of what we would identify as soft tissue.
Okay. So there was some soft tissue then?
Yes.
Okay. And did you perform any testing or anything on that?
I did not know.
Okay. Were you asked to?
No, sir.
Okay. And I was just curious. You said that, of course, in this particular case, when you say you perform an external examination, I assume that means you would look at the body in its normal state in a normal autopsy, correct?
In a normal autopsy, yes.
Right. And that wasn't possible here, right?
That's correct.
Okay. And same thing with an internal examination. Again, you'd see a normal body and you would be able to look, I'm not trying to be graphic, but you'd split the ribs and the cranium and be able to pull the organs and tissues out as needed, correct?
Yes, we make the routine cuts to gain access to the organs in the body.
Okay. And again, you weren't able to do that here.
Correct.
But you also mentioned the other thing a minute ago to Ms. Parker, that you were told the circumstances surrounding the death. I'm curious, were you given any of the circumstances surrounding the death, or were you just given the bones and the tissue sample?
No, I knew the circumstances surrounding the death. Our office was initially informed of the death in October of 2022. That the child had been missing for a period of time, and then the skeletal remains had been, or some of them, the whole body was never recovered. Skeletal remains had been retrieved. I got the bones to look at. Basically, my looking at them was limited, and that was in March of 2023.
Okay. And you mentioned one thing to Ms. Parker, too, was talking about asphyxia or suffocation. We understand 20 months old is a bit old for SIDS, correct?
Correct.
But it's not too old for us to asphyxiate, correct?
It depends on, asphyxia is a very broad term. So asphyxia can be choking on a foreign object, for instance, either a food object or a toy or something like that, or a child can be intentionally suffocated. So asphyxia is broad, and a 20-month-old is not too old for
Well, then let's break
that
it
in
down.
the broad sense.
Then let's break that down. What's the definition of asphyxia, so we can start there then?
Asphyxia basically means a lack of oxygen for a variety of different reasons. You may not get oxygen because of a certain position you're in, where your nose and mouth are obstructed. You may not be able to get oxygen because something is obstructing your airway if you choke on a piece of food or something like that. So it's very broad, meaning a lack of oxygen to the brain.
Basically just means a lack of oxygen.
Correct.
It can be because you're choking, it can be because something lodged in your throat, it can be because somebody's strangling you. It can be for any of those reasons, but that's all asphyxia means, correct?
Yes, sir.
Okay. So, and would it be, do you think it would be important for you to know that and you said the other thing you investigate when you're talking to Ms. Parker was about the sleeping area. Would that be something you would need to know for a 20-month-old death?
A lot less important in a 20-month-old because a 20-month-old is able to turn around in bed and move around. They're not as immobile in a sleeping environment as a younger infant.
Okay, well, let's talk about that. At 20 months old, what is a normal 20-month-old's capabilities?
Generally 20 months old, they're able to walk. They're able to roll around in bed and turn from side to side and lift their head. So those are things that they can do.
Okay, so they're ambulatory.
Correct.
They can move and they have their own mind about things, correct?
Correct.
All right. So in this particular case, would it have been relevant to you to know that there was vomit in the playpen where the child was sleeping?
It would have been a piece of information. If I had a autopsy to perform on an intact body, the information about the scene itself would be information that we received that we would take into account.
Was that information that was passed along to you or no?
I'm not aware of that. I'm not sure.
Okay. All right. And that being said, I think that's all the questions I have. Thank you, Dr. Darisol.
Sure.
Any redirect?
No, Your Honor, thank you. May she be excused?
She certainly may. Thank you, Doctor.
Thank you, Your Honor.
Okay. The state may call its next witness.
Marion Lemons. I think when we left off with our last fact witnesses before we moved into the expert witnesses, where we were at is that the team had found Quentin, right?
Yes,
And that was what day?
that was on November 18th.
Okay. In the days following November 18th, was the defendant interviewed one final time?
Yes, she was.
Before we get to that, I want to ask you kind of a few miscellaneous questions about some things.
Sure.
Okay. The first is a question about venue, and I may have hit this, but I just want to make sure. Have you reviewed the indictment in this case?
Yes, I have.
Have you seen that it alleges a number of false statements on a number of different dates?
Yes, it does.
Are you aware of all of those statements and where they were made?
Yes.
And were they all made in Chatham County?
Yes, they were.
That's for every false statement charged in the indictment.
Correct, yes.
Okay. There has been an exhibit admitted into evidence as State's Exhibit 62, Circle K footage.
Yes, sir.
And which one of the two trips that night would that footage have been from, the first or the second?
It's her first trip that night.
Now, have you reviewed that footage?
Yes, I have.
And is it fair to say that it includes a bunch of different camera angles?
Yes.
Is there a camera angle in which you can tell exactly what it is that she purchases?
Yes, there is.
And how is it that you can see exactly what it is that she purchases during that
Yeah.
trip?
So it faces, the camera angle faces the register as well as what is being rung up by the cashier. So you're actually seeing the receipt as it's actively being run up.
I'd like to display for you the portion of State's Exhibit 63 that I think you're talking about. So what I've done here is I've opened up the player that includes all this footage, and it's a whole bunch of camera angles, right?
Yes, it is.
In here, we've picked the register camera that you're talking about and made it full screen, correct?
Yes.
Okay. So sort of an overhead view of the register that she pays at?
Correct.
Okay. Can you tell us where on the screen we can see what it is that she purchases? And you can step down to do that.
So on the left,
Walk us through it line by line, please.
on the left side of the screen, you see like an itemized list of what's occurring with the register, as well as a quantity. So our targets are right here. We have a natural light 25-ounce can. The quantity's changed to 2 cans. And then we have a Cigarillo's green, quantity changed to 2. And then, driver's license scanned. And that's the transaction for Leilani's purchase that night.
Can you tell us where we are in the timestamp here?
So the timestamp that we're paused at right now is 10:29 p.m. on the 4th of October.
All right, and I'm going to hit play from here and we'll just watch the transaction, okay?
Okay.
Is it moving or not? stop the playback at 10:31:22. Now, moving on to another miscellaneous item. Do you remember hearing Officer Schenker of the crime scene unit or forensics unit talking about the substance that was found in the back of the Dodge Journey?
Yes, I do.
Did you look back at the file to see whether you could figure anything out about what that was?
So in Schenker's testimony, and it was previously mentioned, we believed it was like a rice cereal. That's also what Ms. Leilani told us it was.
All right, and have you prepared an exhibit to address this issue?
Yes.
I'd like to approach with what I've marked as State's Exhibit 94A and 94B. Do you recognize those two items?
Yes, I do.
Can you describe to us what they are?
Sure. 94A is going to be a PowerPoint of what 94B's printout is. It's a collection of photographs with the rice cereal.
Okay, so 94A is the disc, 94B is the printout of that.
Yes.
All right. I would introduce this in as 94A and B.
No objection, Your Honor.
Okay, 94AB or admitted without objection.
Just need a moment here, Your Honor. All right. I think I've got this working right now, and I'm trying hard not to have to ask for a recess here, because we're in the home stretch, okay? What does this first slide here show?
So this is a photograph of the back of the Dodge Journey that was taken on 10/6, and it's kind of just displaying the rice cereal in the back of the vehicle.
Appears to be pretty evenly and widely distributed.
Yes, it is everywhere.
Moving to the next slide, what is this that we're going to see here?
This is just a short clip of the interview that we conducted on 10/5, where she's explaining what that is in the back of her vehicle.
Now, just to make sure we're clear here, the date stamp in the top left corner says 10/6. Can you just, I'm not trying to catch you, I just don't want anybody to be confused.
Yeah, it's the 10/5 interview, but it's early in the morning on 10/6. So technically, it's the next day.
Got it. Almost 5 minutes after midnight.
Yes.
Okay. Okay. Yeah, sure. I have to see it. Let me see here. Yeah, I'm sorry, I guess I haven't had to ask for a minute. Almost made it through the whole thing.
5-10 minute break. We'll see how this goes. All right. So, ladies and gentlemen, no research. Don't discuss the case, and you're going to take a quick break.
Jury's exiting.
All right, ladies and gentlemen, please have a seat. We'll take a 5-10 minute break and see how it goes. All right, thank you. We're in recess. The attorneys are present. Ms. Simon is with her counsel. Are we ready to bring in the jury?
As I can tell, Your Honor, but one never knows what the future holds.
That's so true. Please bring in the jurors.
Jurors entering. Jury room is clear, Your Honor.
Thank you. Thank you for your patience. Please have a seat. I believe we are ready to begin. Mr. Dean?
All right, so what are we going to hear in this clip to the best of your recollection?
So this will be myself and Brad Snyder asking Leilani what's in the back of the vehicle. You'll hear her explaining that it's rice cereal.
Listen closely to it because I'm going to ask you a couple follow-up questions, okay?
Yes, and then I want my even like over a month. My friend gave me a big old bag with a whole bunch of baby cereal that she didn't have anything to do with. I put it in the car.
What type of baby cereal? Like
First,
did she put like it's almost like a rice consistency?
rice or oatmeal is what it is. And
What
it
type
was
of container was it in?
the actual container itself that comes in from the store.
What does that look like?
It's blue and it's about this big and comes up like this. And it has a screw on top that pops open. Whatever.
And what happened? How did it come?
Two of them that she gave me, she had just opened and she tried it with her baby, her 9-month-old baby, and it didn't work very well with him. So she gave me those and a whole bunch of the other ones that she bought. When I put it in that car, got home, took it out, the bag ripped, it fell, it spilled. Got another bag, collected up what I could, and took it inside. I still have all that baby cereal from that day except for that one.
And just describe to me again when you came home.
You know, that's something that she's saying happened more than a month ago, right?
Yes.
This explosion of baby cereal in the car.
Yes.
And what did she say she did with the canisters after she had cleaned it up?
Brought them inside.
Took them inside the house, right?
Yes.
Yes, and now.
Move into the next slide. What is this still image from?
So this is the police response on 10-5. It's captured by the body camera footage of, I believe it's Officer Jepson. And we're looking at the back of the residence, specifically right there's Daniel. To the right is the residence, and to the left is the pool.
What time of day is this image, this still image from?
10 o'clock that morning.
And how does that relate to the time that the police first responded, roughly?
It's shortly after their response there, the patrol officers.
Yeah, and at this point, no police officer had been in the house, right?
Not to my knowledge, no.
So no police officer would have pulled anything out of the house and set it
No.
outside? Okay. What is that wooden structure on the right side of the frame?
I believe they described it as like a tiki bar area, but this is just, about shoulder height bar that's in their backyard.
And what is that? What are the blue things sitting on there?
So that is 2 containers, that's 2 plastic containers of the rice cereal, like baby rice cereal.
Moving on to the next slide, what is this image?
This is just a more clear view that Officer Schenker, it's a photograph that he took that night. And again, you're seeing the bar area and those 2 images of rice cereal, or 2 containers of rice cereal.
The next slide, what have we done here? Just zoomed in on that one?
Correct.
Okay. And then the final slide, what is this?
This is just a Google image of what we were previously looking at.
Okay. Gerber cereal for baby rice type?
Yes.
Okay. So those 2 canisters were out there on the tiki bar when police first arrived.
Correct.
And the defendant had told you she took him inside like a month ago,
Yes.
or more than a month ago, I think.
Yes.
Any reason you know of that those things would be outside?
Objection, Your Honor, calls for speculation.
Sustained.
No further questions on this exhibit. Let's talk about the final interview of the defendant. What was the date again?
Her final interview was on November 21st
And where was it conducted?
at the FBI office.
By this time, Quentin had been found on November 18th.
Yes, he had.
And at this point, had you taken out warrants, at the time of this November 21 interview, had you taken out warrants for the arrest for the defendant?
Yes, I did.
Now, were y'all bringing her in there in part at least to notify her that the remains had been discovered?
Yes.
And did she know that before she entered the interview room with y'all and was told that?
That the remains were discovered? No.
Did she know before the interview began, though, that she was being arrested?
She assumed so, yes.
Okay. And y'all had, who did y'all correspond with to get her in that day to the FBI office?
Yep. Her mother, Billy Joe.
And she had been told that the defendant was being arrested that day, right?
I don't believe we told Billy either. I believe they both just assumed that's what was happening that day.
Okay. Where in the FBI office did the interview take place?
It's in the interview room, which is in like the front corridor area.
Now, is it fair to say that this was the first interview in which she was not free to leave?
Yes.
And was in police custody at this point?
Yes, she was.
Given that, did you all, at the outset of the interview, advise her of her Miranda rights?
Yes.
Did you advise her of her right to remain silent?
Yes, there's a form that we read to her, and we provided her with one to read as well.
Did she indicate to you that she understood all those rights?
Yes, she did.
Did she have any questions about any of them?
I don't believe she did, no.
And did you all ask her whether she would waive those rights and agree to speak to you?
Yes.
And did she do that?
Yes, she did.
And was that agreement memorialized on the form that you've discussed?
Yes.
And did she also memorialize her understanding of each of her rights by initialing next to each one of them?
Yes.
I'd like to approach with what I've marked as State's Exhibit 80. Do you recognize that document?
Yes, I do.
Can you tell us what it is?
It is the FBI's template format for advice of rights. This is the document that I believe Agent Solomon read to her and explained prior to this interview.
And were you present for that?
Yes, I was.
Okay. I would introduce this as State's Exhibit 80, Your Honor.
Can I look at it real quick, Judge, just to make sure? I think I've seen it before. Okay. I think I've seen it, but I just want to make sure. No objection, Your Honor.
All right, 80 is admitted.
Now, how long, roughly, was this interview in its entirety?
Almost 3 hours.
Okay. I'm not going to watch the whole thing.
No.
Right?
No.
Okay. Did it, like some of the other interviews we've heard about, start with this kind of long period of rapport building?
Yes, it did.
And eventually, did you all get into the substance of that?
Yes.
Have we prepared a disc containing a few excerpts from this interview?
Yes.
And do those excerpts capture essentially what her story was for that day?
Yes, it does.
I'd like to approach with what I've marked as State's Exhibit 81. Do you recognize that?
Yes, I do.
Can you tell us what it is?
It is a collection of the November 21st interview. It's a CD.
Series of excerpts.
Yes.
Do you remember how many total?
There's 3.
Okay. And what, could you just kind of describe to us what the 3 excerpts are, if you remember?
Sure.
And if not, we can just throw them
through them.
Yeah, so the first one is going to be kind of the initial conversation that we had about cocaine. In this video, you will see Leilani telling us what cocaine does to her, what she's learned, through some of the counseling that she's had. She'll talk about how she's, experienced delusions, change in emotions while high on cocaine, and we're discussing whether or not that's what happened that night. The second clip is Leilani changing the trash story. She's talking about how there's now 2 bags of trash, and we're discussing whether or not Quentin was in one of those bags of trash. The third clip is us confronting Leilani on how many stories she's told us over the last 2 months and why she told these stories.
Now, what was kind of her core claim on this day about what she remembered about the Azalea trip and the time period leading up to it? What was she saying to you on this day?
The majority of the time, she's saying that she doesn't remember the Azalea trip. She only remembers returning home, specifically going over the railroad tracks right before she gets to her residence. There's also other times where she says specifically that she was throwing away just trash, shrimp pasta, while at Azalea.
Did this claim that she was making to you about just not remembering anything from like 11 something to when she was driving home from Azalea sometime around 1:20 onward in the morning, did this to you conflict with things she had told you before?
Yes, and in the same interview.
Okay. Do the clips on this disc fairly and accurately depict the portions of this interview that you're describing?
Yes, they do.
Other than it being excerpts cut out of a larger file, has it been altered or modified in any way that you know of?
No.
Your Honor, I would introduce this as State's Exhibit 81.
So can we approach on this exhibit real quick? I just
Yes.
want to put something on the record with you.
Okay, we are back on the record.
No objection, Your Honor.
All right, thank you, Mr. Hilliard. State's Exhibit 81 is admitted without objection.
Before I hit play, where are you in here?
I'm right next to Agent Solomon, to her right, but I am off camera. Occasionally you'll see my arm, but the majority of the time I'm off camera.
All right. This is the first file on the disc. It is 20 minutes and 1 second in length, and I'll play that now.
Only something fiber consumes alcohol. So I know one drink versus several drinks feels. So how does like the equivalent of that? Like if you had your normal, like what does it feel like when you tripled your normal?
Honestly, time goes by quickly. It's almost like you're discombobulated a little bit, if that makes sense. You're so high, you kind of lose touch with reality.
So how does that usually feel? Like what?
It's almost like that tunnel vision. You focus on just one thing, down, getting high.
Yeah.
Just looking, but you should have more. You're just focused on that one thing. But when you get that high or whatever, you start like, as they said, like, I didn't know the shit like made sense. It's like delusions in your own mind, but you lose touch with reality.
Like are you seeing things, or your brain is just like making up stories?
Your brain makes up shit.
Yeah.
You can't, you end up doing things like, you don't even remember like getting up and making a pie and that happens a lot. There's plenty of times that I have woken up in the past and like there's food out there or cars going somewhere else and I just don't know who would.
Yeah, and that doesn't terrifying. That like Danny for like going out
Or when I was on mistake or something, I swear now that you did it.
But you think it was you and you were just on.
It's a possibility now that I know the effects, the extent of the effects that it can have on your brain, burns holes into your brain.
How long does that last? Like that particular feeling?
It's hard to,
Like it's 15 to 30 minutes for how long? Like what does this combo do?
makes you very energetic, very numb feeling, and you're having a lot of racing thoughts. Sometimes I hear things and it's not true, right there. Sometimes you see things that's not there. But there are times that they don't eat, like shadow people. You know, there's times that they're late for days on it. I'm not sure if I'm able to get them. Me too, as a kid. And honestly, I can't even tell you half the shit I said. However, I could even tell you half the shit I said, you know, during those times. It's like, it's all a mixture of things, but I can't tell you what was going on.
Will it come back later? Or is it just like,
It's almost like you're playing like a dream. You might get bits and pieces here and there, but you never get the full thing at the time.
so it's not like a dream where you were kind of aware?
And you get bits and pieces here and there, but you never get the full. This, you know, not sometimes someone's like, you did this, and you're like, no, I didn't.
Yeah.
Same thing happened when you get so high.
So
It's like, you just don't know. It's almost like the light is on, you know, it's,
you're like on autopilot.
yeah.
So like in hindsight, now you think that's what happened?
There's a possibility. So I was still crying in the hospital when they mentioned that somebody when you get so high that your brain kind of just shuts down and you don't want to bother.
Yeah.
Yeah. And because I went lost in the sand and just started crying and she was just like, what's wrong? And I was just like, I just don't know what to think anymore. And naturally just go up to things that I was even where it was happening.
Yeah.
Yeah.
Cause I mean, it sounds like at least by like 1:30, you were pretty, at least alert enough to drive safely, you know, and all that. So couldn't have been for very long if you did consider it like that, right?
They say that it can last between up to an hour to 2 hours. Like you can move and function like you're home. Even in your head home, but you're not.
Yeah.
Yeah.
So by the time like it then you kind of come out, your memories get more clear, and you know remember driving and you know operating a car and going different places. It's kind of click back in.
I mean, like, trying to make sense of everything. But I can't make sense of what happened before I left the house is so trying.
Yeah.
That makes sense. No, I don't know exactly what happened.
Do you remember driving?
We're driving back. I'm driving back home. There's a whole other.
I don't know, feeling. Do you remember any feelings or?
Well, I felt a lot of numbness. I had to do with college drugs. Honestly, they numb your feelings. They're like a suppressant. They numb your feelings. They are just everything. Your body in general. Your lips, your mouth, your skin, everything is numb. Like that on somebody put their head in the sweat.
You would have later.
Later, yes. Later. Just, it's devastating. Everything I know is the same thing to this.
My mommy, they know I have been here with you from the start. I think you know that.
Yeah.
Her and I have basically been attached to your family, and I think both of us have an emotional connection to what happened.
Yeah.
And everyone right here wants to know what happened.
Which is one budget problem. Let's go. Let's go. And that's how it does and everything. And I start putting the pieces together for that, you know?
Yeah. You know,
And so
stories from the media, and I'm sure you are. But we don't know what they're going to say when it comes out that we found him. You know, and we've seen how they treated you for the last, almost 2 months. And without your side of the story, it's going to be whatever they want to say.
I'm not there for that. I don't remember hurting him at all. I don't remember taking him and doing anything like this.
She's never coming back.
I remember coming home. I got home at the end of the night. It was like a funny bad day. It was like everything was just normal. I don't know, my home and didn't understand exactly what I was in the car. But it made sense.
What about next morning? When you went to church?
So when I woke up, devastated. When I went back to look at the thing, he wasn't there. I was really devastated. I just started screaming and calling everybody for help.
So when did you remember that stuff that happened? First, I think she means that it's right. Which is something.
The dragon?
Yeah.
When I talked about it, I was twins and I started early shots and everything. Not doing. Just did everything, but I did something like that and taking me there with some drugs or pick up some drugs somewhere. I wasn't before. And, fuck what I did. So much going happened and people that did the hotel. I don't know what to do about stuff like that. Things about all these things about the drugs that was doing now just baffles me. Because I don't understand. Well, they even made it do some crazy shit. I don't know.
I mean, when you talked about like the delusions and things like that, or just Francie's mind, is there something that would, being up when you're not supposed to be, or like demanding some attention, is there something that?
He was a good baby. When I was trying to lay down, he would sit down, latch on the sofa.
Was that ever annoying or just kind of really distracting?
It was cute, honestly. It was so much. It was singing to himself. We would sit there and laugh about it, trying to stay up his side, so we would jump out. I'd peek around the corner.
I have 2 cats and I'm very together. I can't imagine 3 children and the stress and everything that happened that night.
He can't see and just kind of shorty. It's already walking so much. Like I was saying, sometimes when people are drugs, when they realize they're not there, they'll say they're drugs. And they're just all of that.
It's a hard thing to come to terms with. I think that the Well, it sounds like the eating part, at least in terms of like removing it from allowing you to come from the outside in to help with that kind of thing too. Just kind of curious. So you woke up that morning, I was sleeping obviously, and remember, coming back from Thalia. it's not like that. Yeah. Do you remember going into a seminar? Like a term or anything? Hearing anything? Because you gave a pretty detailed story. And I was looking about like 360 and I was just like, no shock. I went on there, that's what it was. And I was like, no, how many misty or something, you know? Yeah. It's too many things. Oh, no, I'm coming working with you. I'm trying to get out of my brain, but it's so hard. I want this picture like, I remember dreams in my house and I don't. They say some things come out of dreams. And you know, yeah, I just don't remember dreams. You know what? You don't have no dreams or anything like that. You don't understand it. What do you think people are going to say when it comes out that we found him? Poor mother. I'm trying to try. God knows exactly what I'm saying. What can you see of that? There's nothing to do with it. It's nothing that was planned out. It's not like I wanted to. Do you think that you may have? But you know that things weren't laid out, and like you said, you worked really hard and must, you know how to get clean and recognize safe coping mechanisms and that kind of thing. But a lot of times the wrong things line up, and something happens, and you remember leaving the dumpster, which is exactly how we were found him. We found him exactly in the middle of where we were looking, based on what you told us about him to Griselda and stopping at the dumpster. We wanted, because it was, so knowing all of that, knowing you're in a state and something happens and you try to fix it right away. And I think in some ways try to make it go away like it wasn't real. And you woke up and realized it was real. But, we know that that's what happened, and it's maybe something you're going to have to come on with, and we know that people have been very cruel in the YouTuber culture and all of that I had never experienced or seen. I had never seen anything like that. That they're going to make their own stories now. And so I really hope they, can give you a second to just kind of think of what your story would be, for yourself. Because the only way you give Quinn peace and you give yourself peace and move forward for all of you is to realize and acknowledge what happened. And like you said, there was no premeditation, there's no planning, and frankly, I think if you would plan things, it would have not gone the way it went, because it's not planned, but your actions from that night what brought us all here, and again, because you remember the trip to the dumpster is how we found, again, from head to toe, we found it. And so I really want you to did nothing close to the line of hope. Whatever possibly done, and I don't know what possibly happened in the house. So I woke up and it was gone. And I'm gonna look down it. I don't know that damn college. This is my life now. Because I'm going to be building up the raise up. people right now. We're gonna dollar science on that. We're gonna see what they have to say. I really don't think that you wanted this to happen. And you know, there's still your reason. And even when he's not here, he's still your reason. All three of them. And right now, the reason for Quentin, that I think we all want, you know, this is what we know definitively happened. And now there's two of you that know that story, you know. And hopefully Quentin's able to tell us. And we really hope that you're able to know your own truth and kind of know what will, you know, your own action place, because there's no way for you to heal from it without being motivated and see it as what it is. Like you said, it wasn't this long-term Ocean's 11 paper of, you know, harming your child. You know, you did harm your child and you hit him, you know, and that's just, it's just facts. It isn't in your head. No. And I mean, I've never lied to you about anything. I've never said anything to you that I didn't know or fact to be true. And I don't believe that you hit him. But you hit him in the dumpster because you had harmed him in some way before that. Like, how scary is it though to think that you have this gap? So how do you get it?
I asked her about it. She thought I'd get her back, but she said, honestly, if you were black out, you might not. So if you get a chance, you're just like when somebody blacks out from any trauma. You might not.
Yeah. The brain just didn't process it anymore. What's the last thing you remember before?
Same room again.
And then it goes to driving back from Zoe. Did you see him in the bed right when you got home, or at some point, like, you came home and did a line and you saw him?
I got home and was he was lying in bed.
So that was like the
10 something, 10:40 something.
memory from the right trip. And that's your last memory all of that night. You don't remember.
And then
Yeah.
I said I had the rubber tracks. And she's like,
Now, at the end there, what did she arrive at ultimately for the period of time for which she was claiming a total lack of memory?
She said the last thing that she remembered was looking at Quentin and then driving back from Azalea.
Looking at Quentin after the Arkwright trip.
Yes, and then blacking out and then coming back to it as she's coming back from Azalea.
And what was she saying in there about what caused her to start forming memories again on the way back from Azalea?
Hitting the railroad tracks.
Okay, so fair to say she's claiming something like a 2-hour plus total lack of memory?
Yeah, she would have gotten back from Arkwright shortly after 11, and then she gets back from Azalea around 1:30. So yes.
Okay. And is it fair to say that that period of time for which she's claiming a total lack of memory would encompass both the time period in which law enforcement believed the murder had occurred and the time period in which the disposal of Quentin's body had occurred?
Yes.
So just like the times of the crimes.
Yes, it is.
This next clip, what is this clip?
So this is us touching on her previous statement back on 10/12, where she's describing very vividly how she threw away the trash, and we're asking her to revisit that memory that she's had and she's telling us that there's 2 trash bags, and then you'll hear me ask specifically whether or not Quentin was in those trash bags.
And does she outright deny that Quentin was in one of those trash bags?
She does not.
And this clip is later in time than the bit we just watched.
Yes, it is.
This is when y'all are kind of reminding her of her previous statements, which seem to conflict with what she's just told you about this total lack of memory.
Correct.
The story with Sam and Brad. There was another trash out there. Was that what Quentin was in? Before, there was like 2 minutes later. I can't remember. I know there was full of food. When I was trying to get rid of them. Did you use a trash bag? I don't recall if there was a trash bag. Okay. I don't recall if I was from before I left their house or trying to.
Did we hear you? She said there was a trash bag in there, right?
Yes.
And then you said, "Is that what Quentin was in?" Is
Yes.
that right? And at that point, did she say, "Well, there were 2 trash bags"?
Yes.
And did we hear you ask her, "Did you use a trash bag?"
Yes, I did.
And by that, did you mean, did you use a trash bag to dispose of Quentin's body?
Yes.
And was her answer to that, "I don't remember grabbing a trash bag"?
That was her answer.
In other words, she didn't say, "Well, hold on, I didn't dispose of his body."
She did not say that.
Mr. Dean, how long is this setting up?
It is about 3 minutes, right?
Okay.
Or this would be the 3rd one. Do you remember what it is that we're going to hear in this clip, more or less?
So we're challenging her on her many stories throughout the last 2 months and why she said these stories to us if she didn't have a memory, why she constantly changed, what happened that night, who went out to Azalea. It's kind of just our last crack at trying to find out what really happened.
Leilani, why did you tell us several times different stories? I'm trying to comprehend. You said it was 2 times that Brad sat there and told me that I killed my son. He was like, "No, mother, isn't it?" And he watched me. I had no memory, so I knew exactly where I know it was trash. Right now, I can make sense of this. It was totally, or jail. And he said there was no way to go or jail. So I think it was the other theory. Which is? I was totally trash. Get out of the house first. Wait for Daddy. But we know now that that trip to Azalea, Quentin was there. So go back to that statement you made to Savannah and Brad. You remember seeing the trash bag, looking into it? I didn't look into it. Tired it was. Right. So you didn't actually look into it? The only thing I took in was display food. You were pretty restricted though. Because we had the smell, the slow like shrimp pasta. Not even the smell. It's the same smell of beer when we took it out of the fridge and threw it away. Do you remember wrapping it up? I remember tying it back together so I could throw it in there. It wasn't heavy at all. No. Not really. Really. Do you remember him being in that trash bag? No. We know at this point he was. I don't remember that. I don't remember him being in a bag. I don't remember leaving my house. I don't remember that. I don't remember that. Why did you tell us all the story about just all of these stories, pretty much? I'm trying to get sense of it myself. He was the one who said, "I saw you in the trash and threw it away." And let me show you something. construction of the mountain. What that looks like at home is trash. And everything so wrapped in that is trash. You see how little those people are. Do you think that we could have found him if we didn't know that you put him in the dumpster and we knew exactly where that dumpster went? Yeah.
Did we hear her say the word theory at some point in there?
That's what she refers to it, yes.
What was the theory thing? What was she saying?
She's saying that every time that she lied to us was her sharing her latest theory.
In other words, she wasn't claiming that she was making factual statements about what happened. She was saying she was just kind of throwing out theories.
Yes.
She was describing was she describing the Oragel story as just a theory that she had proposed?
Yes.
And was she saying that she had only proposed it because, well, she had come to and found Oragel and was trying to figure out how?
Yeah, she said she found it in her vehicle, and that's the only thing that made sense to her.
And did she describe her story about throwing away trash as just a theory that she had come up with in response to Brad asking her whether she had thrown away trash?
Yes.
Now, I want to just ask you about a couple features of these prior stories that she's referring to as theories, okay?
Okay.
You talked to her on October 5th when she first launched the Oragel story, right?
Yes, I did.
Did this story include who she had gotten it from?
Yes, it did.
Did it include where she had gotten it?
Yes.
Did it include when she had gotten it?
Yes.
Did it include why she had wanted it and obtained it?
Yes.
Did it include details such as how many tubes of Oragel she got and how many were opened already and how many were unopened?
Yes.
The story about throwing away trash that she gave to Special Agent Snyder and Special Agent Solomon on October 12th, did that include such details as specifically what the trash was?
Yes, it did.
What it smelled like?
Yes.
How long it had been in the car?
Yes.
When she first registered the odor of the trash?
Yes.
What kind of trash bag it was?
Yes.
What color the ties on the trash bag were?
Yes, it was a very vivid story.
An admission to having looked inside the trash bag before throwing it away.
Yes, she said that.
An estimate of how much the trash bag weighed.
Yes.
And statement about the exact physical mechanics of how many hands she used to put it in the dumpster.
Yes.
You had either conducted those interviews or observed them prior to this interview, right?
Correct.
Did any of those things sound like mere theories to you at the time that she said them?
No, they did not.
Now, in this interview, particularly in the first bit we watched, the 20-minute bit, was she asked at some point by you, I think we can all agree that something did happen.
Yes.
And did she nod her head yes in response to that?
Yes, she did.
Was she asked, do you think you may have killed him or something to that effect?
Yes.
And is it the case that she was just not able to give an answer to that or just didn't really say anything?
That's correct.
Was she, at some point, did Special Agent Solomon say, you harmed your child and hid him, or words to that effect?
Yes, she said that.
And is it fair to say that the defendant just did not affirmatively dispute that? She didn't say, no, I didn't.
She did not.
And separately, did Special Agent Solomon say, you hid him in the dumpster because you had harmed him in some way?
She said that.
And did she also fail to dispute that statement?
Yes, she did.
One moment, please. No further questions, Your Honor.
Any cross?
I do judge, but I was gonna say this might be a decent time for a little break in case it takes a minute.
All right. The time now is 2:36. Let's just take a few minutes to shift. Let's make it about 10 minutes. That will be 2:46. All right? All right, we're in recess.
Jury is exiting.
Thank you, Smith. And with that, we're in recess. Thank you. reflect that attorneys are present. Ms. Simon is with both her counsel. And so, Mr. Hilliard, are you ready for cross-examination? Okay, is the state ready to proceed as well?
Yes, Your Honor.
Okay, please bring in the jurors.
Jurors entering.
It appears that everyone is not ready. So the jurors who are present, if you'll go back to the deliberation room, that's fine. On second thought, it appears that things are working out.
Jury room is clear.
All right, excellent. Do y'all want to change the order?
Yes.
I can tell that was going to be a thing. Everybody, please have a seat. Okay. So, ladies and gentlemen, we're going to move now to further testimony. Okay. And no one discussed the case or did any research? No, ma'am. All right. Thank you. Mr. Hilliard?
Thank you, Judge. This is the first time I've really had a chance to speak to Ms. Lee, so I'm going to go way back to the beginning for that reason, okay? Give me 1 second. I picked up the wrong pad. So you arrived on scene at 10:30 on October 5th, correct?
No, after 12.
After 12? Okay. And how long were you on scene on October 5th?
On scene, probably about an hour.
All right. And at what point in time did you take Miss Simon, Mr. Youngkin, and Mr. Simon over to the precinct that day?
I asked one of the patrol officers and some of the detectives to have them transported probably within that hour.
So probably around 1 o'clock then? Just trying to get a general idea.
Yes.
So on October 5th, around 1 o'clock, all three of them went over to, I guess it's the police.
The
precinct?
headquarters?
Yeah.
Yes, sir.
And how long were they there on October 5th?
Until about 2 a.m. the following day.
So about 13 hours, right?
Yes, sir.
And over the course of the trial, we've seen a number of interviews during this time, correct?
Yes, sir.
And during that time, you were also speaking with, I'm going to assume, I'm not trying to put words in your mouth, you're speaking with Miss Simon, Mr. Youngkin, and Mr. Simon, as well as others at the time, but those were the three main ones, right?
That our team spoke with, yes.
Yes. Okay. So that was 13 hours on the 5th to the 6th. When did you next speak with Miss Simon or have your team speak with Miss Simon?
We were in communication with her for probably the next 2 weeks, almost every day.
Every day? When you say ran communication, I guess that means phone calls?
Yes, sir.
Okay. And when was the next, I guess, in-person interview?
October 8th,
And how long was that one?
almost 2 hours.
And that was at CCPD as well?
No, that was at the FBI office.
And give me 1 second. I'm running out of room here quickly. And when was the next one after that?
October 12th.
And how long was that one and where was that?
That was almost 2 hours as well, and that was at the FBI office.
And during this time frame too, this is the phone call? You still having phone calls during this 2-week time frame?
Yes, sir.
All right, so it's 13 hours on the 5th, 2 hours on the 8th, 2 hours on the 12th. When exactly was the hotel room video and audio?
What part of it?
The actual time they were in the hotel room when y'all were videotaping it.
The 8th and 9th.
That was October 8th to 9th, correct?
Yes, sir.
And during the same time frame, you were wiretapping Daniel Youngkin's phone from, I think, around the same time, October 8th or 9th, for about 60 days, right?
Yes.
Intercepting all of the phone traffic between him and her.
Yes.
And just, not that it matters, a rough estimate is even after you arrested Miss Simon, you still intercepted his phone calls between them, correct?
Yes.
So that was at least, generally speaking, between October 8th, 2022 to December 8th, 2022, correct?
Yes.
All right, so that's going on at the same time the other interviews are going on, right?
Yes.
So October 12th, I'm sorry, was the next in-person interview. When was the next interview that your team did of Miss Simon at that point?
After October 12th? October 31st.
All right. And how long was that one and where was that one?
That was at the FBI office, and I believe that one was also probably 2 hours.
2 hours. Okay. And the next one after that?
Would be her final interview when she was arrested.
All right. And what day was that?
That was on November 21st.
And that one was how long?
3 hours.
And so from October 5th to November 21st, were you still in constant contact with her?
The team was.
The team was. And by the team, you mean yourself, Agent Solomon, Agent Schneider, and anyone you delegated to do that, correct?
Yes.
All right. Now, and you said that on, I think it was November 21st, she expected to be arrested when she came in, correct?
Yes.
And you asked her to come in, correct?
Yes.
And she came in, correct?
Yes.
All right. Now, we've seen some of the excerpts here that you put up here today. Now, let me ask you this. What interrogation technique were we just witnessing on this particular video?
I don't have a name for the technique. We were having a conversation.
All right. Well, you said you don't have a name for it, but you've gone to the academy, correct?
Yeah.
And you were trained in interrogation techniques, correct?
Yes.
And what interrogation techniques were you trained in?
I don't have the name for the techniques. My way of doing it is just making sure I have the full story. And if I don't understand anything in somebody's story, I just keep asking questions until I do.
Okay. So in this particular technique, though, which we just witnessed, and we've seen the entire time, is it safe to say that you're putting individual stressors on the interview subject?
In which interview?
All of them.
It depends on what you would say is a stressor. We're talking about her dead child, but
Okay. Well, and that's my follow-up question. Wouldn't you think speaking about that would be a stressor?
yes.
Okay. And wouldn't you think that speaking about that would evoke an emotional response?
Yes.
Okay. And you seem to have had opinions about that emotional response, but what have you been trained that is the appropriate emotional response? Do you have a level?
Can you restate your question?
I can. So if you are overly hysterical, then you're overly hysterical. If you are not hysterical enough, then you're not hysterical. How do you gauge the appropriate response level to your questioning for you to be satisfied? What's the right answer? What could ever be the right answer?
For what appropriate reaction she had?
Yes.
I'm basing that on previous interviews I've done with families that have lost their children.
Right. But every individual is different, are they not?
Yes, sir.
Okay, so in this particular case, a number of times Mr. Dean has asked you a number of questions, and you said it wasn't emotional enough, or it was too emotional, hysterical. And how do you make that determination? What is the appropriate objective standard by which you can judge that?
I believe I focused on the October 5th interview when she would do the screaming and yelling portion.
Okay. And that was when you made your decision, correct? October 5th?
Decision about what?
As to how and where you were going to focus your attention in this investigation.
No.
Okay. Then when did you decide that Ms. Simon wasn't your prime suspect?
She was our prime suspect, you mean?
No, I said, when did you decide that she wasn't? If you said you didn't do it on October 5th, okay, so you're saying she wasn't your prime suspect on October 5th?
No, we looked at all three of the adults in the residence as possible suspects.
Okay. So that being said, you looked at all three of the adults. Did you ever look outside of the residence as a possible suspect?
Yes.
Okay. And what did you do to pursue any of that?
Outside the residence? So we did a canvas, as we've previously talked about.
Right.
No leads came up with that of any suspicious persons around the residence. We set up the tip line that did not prove any other suspicious persons. We spoke with probably every single family member of this family in Savannah. None of those had any guesses on who it could be, including the 3 people that lived there.
And let me ask you this about your interviews with Ms. Simon. All of the interviews, she was free to walk away or not engage in those interviews, correct? Correct, because you already had warrants at that point.
Yes.
Okay. So and even knowing that, she still came to that one, correct?
Yes.
Okay. Now, Mr. Dean asked you a question about whether or not she denied something, but not denying something is also not admitting something now, is it?
No.
They're not the same thing, are they?
No.
Okay. So, and in my recollection was, I don't think she's ever, in any of the interviews, admitted to harming Quentin, has she?
No.
Now, in the last interview, at that point in time, had you ever determined a manner or cause of death for Quentin Simon?
I have an opinion on how he died.
I didn't ask you your opinion. I asked you if you determined. Has a doctor made a medical determination as to manner, method, or time of death?
No, due to the remains, we were unable to find that.
So that's no. Okay. And that being said, when you were interviewing Miss Simon on that last particular day, you focus on a lot of things that weren't said, but she never said that she killed Quentin, and she never said that she disposed of his remains, did she?
She said she did not remember.
Okay. Now, you said you have an opinion, but opinions are just that. They're not based, they're just your opinions, right? I have opinions, you have opinions. People have opinions, correct?
Yes.
Okay. And opinions are not evidence, are they?
No.
That's all the questions I got, Judge.
No redirect, Your Honor.
Yes, ma'am.
State may call its next witness.
May we have a moment, please, Your Honor? Your Honor, subject to verifying that all of the evidence that we've offered has been formally introduced and admitted. The state rests this case.
And so with that, jurors, I'm going to ask you to return to the deliberation room at this point.
Jurors are exiting.
Jurors are clear, Your Honor.
Thank you, Deputy Smith. Everyone may have a seat. Okay.
The state just wanted to verify our exhibits, and we should have exhibits 1 through 94, and 94 is an A and B, in evidence with the exception of 83.
Microphone.
Sorry. What I was saying was the state should have exhibits 1 through 94, which is an A and B exhibit in evidence with the exception of state's exhibit 83.
So 1 through 94, A and B, but not 83.
Not 83. We just wanted to verify that with the clerk.
Thank you, too. Thank you. Mr. Clerk? Madam Clerk. Okay, and that's what you show is in evidence.
Thank you
Okay.
very much, Your Honor.
Thank you, Ms. Parker. And then, is there any motion by the state? Excuse me, by the defense?
Yes, ma'am.
Mr. Purse?
Here, let me give Mr. Purse the microphone, Judge.
Just a moment before you begin, Mr. Purse.
Your Honor, at this time, I'm going to focus my argument as to a motion for directed verdict. Just so we're all on the same page, I'm focusing on counts 1, 2, 3, and 4. And I'm going to take them kind of in separate batches and then all together with my final thought.
All right.
With respect to counts 1, 2, and 3, that allege that Leilani Simon committed malice murder and felony murder of Quentin Simon, the defendant moves for a directed verdict of acquittal. First, there's no direct evidence to support these claims. The state has presented theories and its conclusions, but has presented no direct evidence that Leilani Simon committed these crimes the way they're charged in counts 1, 2, and 3 in the indictment. I think the medical examiner's testimony is significant. She expressed no opinion about the manner of death, the cause of death, the time of death, and even as an expert in her field, couldn't even express an opinion that Quentin Simon died as a result of the commission of these crimes. That leaves us with circumstantial evidence. In Georgia, and I'm quoting Official Code of Georgia 24-14-6, quote, to warrant a conviction on circumstantial evidence, the proved facts shall not only be consistent with the hypothesis of guilt, but shall exclude every other reasonable hypothesis save that of the guilt of the accused. With respect to the circumstantial evidence argument connected to the murder claims, again, the medical examiner testimony is extremely significant. because what it presents and what it leaves out raises lots of hypotheses as to what happened to Quentin Simon, and does not only establish the guilt of Leilani Simon as alleged in the first 3 counts of this indictment. With respect to count 4, that alleges concealing the death of another. Concealing a death is against the law in accordance with Official Code of Georgia 16-10-31, which provides that a person is guilty of this offense, and I'm paraphrasing the statute, when a person conceals the death of any other person and does so to hinder a discovery of whether or not such person was unlawfully killed. In this instance, the medical examiner's testimony again failed to establish that Quentin Simon's death was the result of any unlawful act. Basically, all 4 counts of this indictment, I should say, is grounded in a bunch of theories and the state's speculation and conclusions. With respect to that, in suggested pattern jury instruction 1.20.20, Georgia law provides that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a suspicion or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. At this point, the state's evidence is ground in speculation and grave suspicion, but not on facts and not on evidence. On behalf of Leilani Simon, we move for a directed verdict of acquittal with respect to counts 1, 2, 3, and 4 of the indictment. Thank you.
Thank you, Mr. Purse. All right, Mr. Dean.
Your Honor, I'll be brief. We've presented sufficient evidence for the jury to find, based on both circumstantial and direct evidence, that the defendant is guilty of all 4 of those counts. The Wyatt case is clear that when we allege that certain facts are unknown, such as manner of death or certain other facts in the murder counts, that those become material allegations that we have to prove. And I think that Mr. Purse's understanding of the medical examiner's testimony is exactly backwards. It does not support a directed verdict on any of these counts. In fact, it was offered to prove the material allegation that certain facts are unknown. And it does that. We've said in the indictment that she killed him in a manner unknown to the grand jury. And that was the point of calling the medical examiner to say, I couldn't do an autopsy because of the condition of the remains. So we've proven that. Circumstantial evidence does, a circumstantial case does have, the evidence does have to exclude all reasonable theories other than guilt, and we've done that by presenting affirmative evidence that there was no medical event, there was no accident. The defendant was asked repeatedly about that and denied it each time, and further, her actions after the fact were totally consistent with any type of accident. There are only so many ways to die, and we've excluded all of them, but in intentional act of violence that resulted in Quentin's death. In concealing the death, it requires that you conceal the death of another, such that it hinders, such that you hinder the investigation into whether the person was unlawfully killed. I don't know whether there's ever been more straightforward body of evidence in support of a concealing the death charge. I could go on. I hope and doubt that the court needs me to, so I'll wrap it up with that, Your Honor.
All right, thank you very much. I am going to find that based on the argument made by the state, the court finds that there is sufficient evidence that has been presented for the jury for the charges in the indictment to be considered. So a motion for directed verdict is denied. All right. Are there any other motions from the defense?
We probably need to engage in the right to testify colloquy at this point, Judge.
We do. So, I'm going to ask Ms. Simon to come up to the witness stand. And before going to the witness stand, if you'll be sworn.
Raise your right hand. Please swear.
The evidence you shall give the court on the issue pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Ms. Simon, just have a seat on the witness stand, please. Okay. All right.
You want me to do it? Or you want me to do it, Judge?
I'm going to start out with Ms. Simon. Ms. Simon, please state your full name.
Leilani Murray Simon.
Okay. And you're doing the right thing, just talking to the microphone so the court reporter can get it. I think you've heard me give that instruction a couple of times.
Yes, ma'am.
All right. Do you understand that you have a right to testify?
Yes, ma'am.
And that if you want to testify, no one can prevent you from doing so?
Yes, ma'am.
Do you also understand that no one can make you testify? No one can compel you to testify? Do you understand that as well?
Yes, ma'am.
And you have the right not to testify if you don't want to. Do you understand that?
Yes, ma'am.
All right. Do you understand that not you're a lawyer, but you personally are the one who decides whether or not you will testify?
Yes, ma'am.
Do you understand that if you do not testify, that upon proper request by you, the court will instruct the jury that your decision cannot be used against you?
Yes, ma'am.
In fact, the court will instruct if you decide not to testify. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you choose to testify, you will be examined by your counsel and cross-examined by the assistant district attorneys in AUSA?
Yes, ma'am.
All right. Do you feel a need to have any additional time to consider whether or not you will testify?
I've been given plenty of time by my attorneys, notified weeks ago
All right.
about this.
Do you need any time to talk with him in private about this?
No, ma'am.
All right. And so do you personally wish to testify or not?
I do not.
And with that, I find that the defendant, Leilani Simon, has decided not to testify with a complete understanding of her rights.
Yes, ma'am.
Before you step off the stand, are there any further questions?
Just to follow up. Is anyone forcing you to not testify or to testify?
No, sir.
Your choice is made freely and voluntarily?
Yes, sir.
Okay. And you've had adequate time to speak with me and Mr. Person about your choice, correct?
Plenty of time.
Okay. Just have to make sure. All right. And that's the only questions I had, Judge.
All right. Ms. Simon, you may step down.
Thank you.
Let the record reflect that Mr. Hilliard is taking some time to speak with Ms. Simon in private at the table.
If I could just have a couple of minutes, Judge, because I want to go back in the back and explain to her. She had a couple of questions about what happens next, and I probably need a few minutes away from everybody to go talk to her.
Let's do that. It's about 10 till, I can't tell the time by that clock. It is 3:20. Okay, so let's step off until about 3:30 or so. Okay, we're in recess.
All right, so as you heard, the court is in recess, and because this stream is about 30 minutes delayed, you can expect them to return around 4. We know in the between time that the defense has rested their case, so you should expect that when we return back from this break. Stay tuned with us. We'll be back as soon as the court returns. All right, everyone, so they should be returning to the courtroom in a few minutes. I just wanted to recap about what we were hearing before the break. We know that the defense did ask for a directed verdict of acquittal in counts 1 through 4 of the indictment, which include the concealing the death of another and murder charge. And I want to play you a bit of the defense's argument on that case.
That facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a suspicion or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. At this point, the state's evidence is ground in speculation and grave suspicion, but not on facts and not on evidence. On behalf of Leilani Simon, we move for a directed verdict of acquittal with respect to counts 1, 2, 3, and 4 of the indictment. Thank you.
And here's the state's response to that.
Sufficient evidence for the jury to find, based on both circumstantial and direct evidence, that the defendant is guilty of all 4 of those counts. The Wyatt case is clear that when we allege that certain facts are unknown, such as manner of death or certain other facts in the murder counts, that those become material allegations that we have to prove. And I think that Mr. Peirce's understanding of the medical examiner's testimony is exactly backwards. It does not support a directed verdict on any of these counts. In fact, it was offered to prove the material allegation that certain facts are unknown.
And so ultimately the judge denying that request from the state and continuing with the 19 charges. So we know that they are back in the courtroom on the live stream, so I'm going to take you to there now.
Yes.
So the jury going to talk about charges?
Yes.
Okay, thank you.
That was so succinctly put. Thank you. Bring in the jurors, please.
Jury room is clear, Your Honor.
Thank you, Deputy Smith. All right, ladies and gentlemen, please have a seat. There were no discussions about the case or research? All right, very well. Mr. Hilliard?
No, the defense rests.
All right, thank you. And with that, ladies and gentlemen, we are going to release you for the evening. There are some legal matters that we need to take up outside of the presence of the jury. I'm going to have you come back tomorrow at 10 o'clock a.m. Please continue to follow the court's instructions. Do not discuss the case. Don't let anyone discuss the case with you. Don't watch television shows. Do not do any separate research. Okay? All right. Very well. Thank you very much.
Jury's exiting.
Please have a seat. Thank you. Thank you, Ms. Smith. Okay, so I've received, of course, the request to charge from the state and from the defense. I've had an opportunity to review both sets, and do we have a copy? Okay, so I'll have a proposed set for you to take a look at, and we can go through those and see where we stand. I'm having the jurors return tomorrow at 10 o'clock, just in case we needed to take up anything earlier than that. I expect us to begin at 9 o'clock. And it may very well be, there are a couple of the counts we had some issue with in coming up with what the charge should be. And so that may take some thought. I certainly would like to hear what you have to say. Let's get those requests to charge to you in just a minute or two, and then we can go through one by one. All right, with that, we're in brief recess. Allow the jurors an opportunity Amanda, and a stack of jury charges are what I need.
Right here.
Okay.
I think we're just maybe going through quickly one by one. I can go ahead and just give them a heads up on some of the ones that there are some.
And we need Miss Simon. For you, the charges as they are put together now, pages 1 through 22. And let's just go in order. Page 2, we have the charge regarding the indictment issue and plea of not guilty, presumption of innocence, burden of proof, reasonable doubt. All of that is pretty standard. Is there anything with any of those? Okay, all right. Grave suspicion.
Does the court want objections or concerns as we go through, or do you want us to hold them to the end?
No, let's go, take the objections as we go.
I would object to grave suspicion. As the court knows, the pattern charges, I don't even know why it's still in there, because the pattern charge says, hey, this is totally unnecessary in light of how detailed and comprehensive presumption of innocence and burden of proof are. And that's supported by a number of cases, but as recent as a 2022 case from the Georgia Supreme Court. At their core, jury instructions are supposed to clarify and illuminate. And I think when that charge immediately follows presumption and burden, I just think it's totally confusing. I hate it. I have a visceral hatred for the grave suspicion charge, and we would ask the court not to give it. One thing that's nice about these cases is they make it pretty clear that it apparently can just never be an abuse of discretion not to. That's our position.
So, Mr. Dean, I ran through the first charges, came to grave suspicion and stopped, because I imagine that you would have a problem with that one. Mr. Hilliard? Mr. Purse?
I think grave suspicion is at the core of this case.
I guess And
I
so
don't,
you
and
wish
I
to
don't
have
think
it.
it's, I don't think, excuse me for interrupting, I don't think it's error for you to give that charge since it is in the pattern instructions.
I don't believe it's error. I'm gonna take a look at that again, but, you know, my thought is to leave it out, but, okay. Put a little star by that one. Jury judges the facts, evidence, direct and circumstantial evidence, credibility of witnesses, expert witness. Okay, witness attacked, page 6. Is there any issue with this charge?
We were talking about this, Judge, prior to it. I don't have a problem withdrawing it. I think we requested it, and I think it just would honestly create more confusion than it would solve. So, my last trial, we had an issue with it, trying to tailor it, and we got it tailored, and I won, but I think in this particular case, it's one of those unnecessary charges.
Mr. Dean, I'm gonna mark it withdrawn.
Yeah, for what it's worth, I agree, Your Honor, and I also agree as to, I would make the same case as to witness supported. I just don't think we had that kind of thing going on with any of these witnesses.
I would agree, Judge, if the attack is coming out, the support doesn't come out too. So.
Okay, so witness supported is withdrawn as well as witness attacked. Witness impeached.
I think that saves it.
Agreed.
Prior statements.
I mean, I would like it taken out, but I mean, if you ask me to enumerate a reason for it, I can't other than my visceral hatred.
Yes,
for some of
okay.
these
So a lot of visceral hate going on here today. Okay, so prior statements remains immunity or leniency granted. We did have immunity granted.
We did, but he asked like 3 questions and answered 3 questions, and it never came up. So I don't have an issue withdrawing it, Judge. I don't
Okay.
see how it's a factor.
Withdrawn. Single witness corroboration, defendant's choice not to testify, statements of defendant. Okay. There was some tailoring, I think. Circumstances of the, statements of the defendant, voluntariness defined, those would remain. Circumstances of the statements, etc. Any issue there?
Not from the defense, Judge.
Okay. Burden of proof as to voluntariness. Okay. Statement of defendant made on November 21, 2022.
Just for the record, just for the record to make the distinction, because some people later on may not see the distinction. My understanding was all of the previous statements were voluntarily made.
Right.
The November 21st statement was a custodial statement, which is why the Jackson demos and other voluntary questions have to be proven.
Right.
So,
Thank you, Mr.
I mean, just for clarification, would the parties like for, on page 8, for it to say something like statements of defendant prior to November 21st, 2022? I mean, I just think maybe some clarification
Or some other language in here just to clarify for the jury that everything with voluntariness is included in addition to the additional stuff that comes after the statement for November 21st, 2022.
with like the constitutional custodial issues.
To me, I think page 8 looks good.
Okay.
Because the jury does have to find voluntariness for all the statements.
Right.
I think the only suggestion I would make is on page 9, when you get to statement of defendant made on November 21. I think the bit on lines 4 and 5 where it says if the statement was given in custody, I think the if part is weird there to me when we're both agreeing that it was given in custody. Makes it a little confusing.
So
I think
your suggestion is to take that,
take the
that in the
Take that.
out.
Take that.
If the statement was given in custody, just take it out.
Just take that out and say, maybe, give me one moment, please, sorry.
You must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of her constitutional rights.
Yes.
I mean, because that's what the pattern,
Yes.
suggested pattern charges say, is that voluntary and then the constitutional rights.
Right, this is exactly what I was suggesting, this is like exactly what I contemplated in
Okay.
the requested instructions.
So I'll just remove that, if the statement was given in custody, since this is specifically directed towards the November 21st custodial
Right.
statement.
I don't have an issue with whether the custodial statement,
Okay.
so we all agree with that.
All right. Moving on to constitutional rights. Any issue there?
I mean, the if part at the outset is, that's sort of like the same deal as the last part. You know, maybe it should say, because the allegedly, you know, because the alleged November 21, 2022 statement was made while in custody as a result of police questioning.
How about simpler, how about if the statement was made while in custody?
Ms. Parker, if you'll just bend that
That's even better.
microphone.
To simplify that, how about if the statement was made while in custody? Since we're not really asking them to find whether it was or not.
Okay.
The only, yeah, I'm not asking them to, but yeah, this is only as it relates to the November 21st statement. Correct?
That's the only one.
Yeah, if it's just for that statement, that's fine.
Moving to page 10, defendant initiating further conversation. Okay.
I don't think that this instruction should be given.
Yeah.
Because nothing was introduced in evidence about any such invocation. I mean, some of those earlier interviews did end with invocations of the various rights, or you know, court found that they were legally ineffectual prior to trial and all that. Those were all redacted at the request of the defense, which I had no problem with doing. But because none of it came up, I think the instruction is just inapplicable to this case at this point.
I tend to agree, given the redactions in the pretrial rulings, Reg, we didn't really get into any of that.
Okay. So defendant initiating further conversation, that charge is withdrawn or removed. Burden of proof as to rights. Okay. Conditions proceeding to consideration of statement. Okay. Prior difficulties.
On the conditions precedent to consideration of statement, there's that bit in there about the rights warning being a condition precedent. As we've been talking about, that only applies to the November 21st interview. So I don't know, I can't think off the top of my head exactly how to tailor that, but maybe it says something like, if you find, as mentioned above, that the defendant's statements were voluntary, comma, and that all of the warnings as to the defendant's rights were given as to the November 21st interview, or November 21st statements.
I think there has to be some way.
There's got to be some way to. Okay, yeah, okay, that's good.
Okay,
That all the warnings as to the defendant's constitutional rights were given if required. Because I think it'll be pretty clear at this point when it's required.
Are you okay with that, Mr. Hilliard?
I am, Judge. I mean, we're speaking of the November 21st statement, and I think we all agree, but as long as we find some way to tailor them, because we don't want to confuse them. So.
That is the most important thing.
And then that same point would apply to the top of page 11. If you fail to find that the defendant was properly informed of her rights where required.
Okay. All right. We'll make those changes. Moving then to the next charge, prior difficulties between parties.
No issue with that, Your Honor.
Okay, Mr. Hilliard?
I would object to that, Judge. If I'm going to, I mean, there wasn't really a prior difficulty. It comes back to whether or not, I mean, I just don't see it as a prior difficulty. Prior difficulty is usually between some sort of incident between the two subjects. I just don't, that charge isn't made for that. So I would object to that being included.
I think the difficulty here goes back to what we talked about earlier. There were witnesses that testified about what they observed as the interactions between the defendant and Quentin. And this does take some tailoring. Mr. Dean?
I think that charge has to be in here. I think typically it comes up more in like adult domestic violence cases, but it comes up in child abuse cases all the time. I think definitionally, the incidents that Talia McCarta and some other people related, they just are prior difficulties under the law, and I think I worry about error if this charge is not included.
I'm going to include the charge. Okay, identification, burden of proof. I don't think there is an issue with this one. DNA. Any issue with that one?
No.
No issue,
Okay.
Your Honor.
All right, definition of crime, intent, no presumption of criminal intent, presumptions and inferences. Okay, we are party to a crime here.
There is, I'm sorry I hate to bring it up at the risk of sounding pedantic, but on 13, there's a typographical error in the bolded language presumption.
I'll change it.
inferences. Okay.
Not interferences.
The old spell check got you there.
It
And
passed the test,
Yeah.
it's a real
And
word.
I read it as inferences, even though I looked at it, yeah.
And there are some references in when they reference the defendant, there's a he and a his.
Yes.
Yes.
I will make sure that the pronouns are correct.
Thank you. I'm sorry.
She said it doesn't really matter whether it says his or her, you know, the general stuff. So.
Okay, anything else? Up to, okay, we're now on parties to crime.
Yeah, I had a question on this one, because,
I think Mr. Hilliard is yours.
no, this was requested by the state.
Okay.
Yeah, I don't think there's
Evidence of that.
No.
I don't think there's evidence of number one and number two. I don't think it's relevant.
I'm not going to say it.
Let me hear from the state.
I'd like for it to stay in.
Party to crime.
Yes.
Why?
I don't think I've ever had a case where it wasn't given, and it allows for people, who think, you know, perhaps somebody else was involved in some capacity. What does that mean for us with this defendant? I like it.
Okay. Let me take a look at that. Go ahead, Mr. D.
No one else is charged. The state's entire theory has been that my client did this alone. And so it's just completely improper at this point. There's no fact, there's no evidence, there's no theory of the case that points to a party to a crime. So we object to it.
All right.
To me, it's just a fundamental instruction that's given in every case that addresses what does it mean, what is required to be criminally liable for something in the state of Georgia.
Okay.
I don't know that it's one of those instructions that has to be explicitly raised by anything somebody said or argued.
I'll take it under advisement.
Thank you, Your Honor.
Thank you. Guilt by mere presence. Mr. Hilliard. Mr. Dean, any problem here?
I'll wait to hear from Mr. Hilliard.
I don't have any objection to it.
Okay.
Neither do I.
All right. Guilt by mere association.
Same, I don't have any objection to that.
Okay. Venue.
I think that's the pattern charge.
It is a pattern charge. Malice, murder. Malice, motive. Okay, felony murder. That's one that we want to make sure, I want to make sure is correct. Felony murder, causation in felony murder. Actually, that's essentially the pattern. The felony murder.
These are from the latest, newest
Right.
charges.
Okay.
Thank you.
That wasn't it. The aggravated assault with an offensive weapon. So let me go back. Felony murder, once I read it, I had it circled for some reason. It's pattern, causation, and felony murder. Any issues with that?
Felony
Okay.
murder, no judge.
Concealing death, simple assault generally.
I think the simple assault has to be given.
Yeah, it's by way of explanation. The aggravated assault with an offensive weapon.
The only suggestion I might make as to that charge is I think we've got it indicted as object that actually did cause and not was likely to cause. And if that is the case, then I might ask that that likely to cause language come out of the last line.
Okay.
I mean, that's not like necessary that it be taken out because that is the definition, but to further tailor it. Am I right about the indictment?
The
You are right.
indictment,
It is charged as did result in serious bodily injury.
yes.
So you would like for it to say, that it actually does cause, and just remove the other.
Yes.
Mr. Hilliard,
He wants it to say actually does cause versus likely to cause.
an offensive weapon is any object that does cause, right?
Or just say causes, I guess,
Causes.
since we're taking that out.
Causes or actually does cause.
How about just object that causes?
Why don't we do that?
Object that causes? I think that's good.
All right,
I don't have any great objection to it, Judge.
okay.
I mean, I think it's, at the risk of being pedantic, I don't want to object to the language.
All right, determining if weapon is offensive, that charge.
And this one's called straight from the pattern.
Okay, cruelty to children in the first degree, that's also statute. Any issue with cruelty to children in the first degree? Okay. Voluntary intoxication, not a defense.
May I, on cruelty to children in the first degree, may I ask that item 2, cruel and excessive, read as cruel or excessive? I know it's charged as, it's charged in the conjunctive as cruel and excessive, because that's how we have to charge, but in terms of what we actually have to prove, it's not necessarily both, it's one or the other. So I would ask that that be an order.
Thank you. Mr. Hilliard?
I would leave the language the way it is in the indictment. I think it's indicted as cruel and excessive. I don't have it in front of me, but
It is indicted that way, but if we don't change that to or, I'm gonna have to ask for a totally separate instruction that the whole like and means or instruction, and I'd rather not do that. Because I think that's like the only place in this indictment where we've got a conjunctive that we might want them to read as disjunctive, and I don't think that it's, I'd rather not ask for the whole separate instruction that, hey, there are spots where, certain crimes can be committed in more than one way, and the state need only prove one, even if they've alleged more than one, and that whole deal. I'd rather just change this and to or and be done with it.
The case law forces us to charge with an and rather than an or, but the case law also says that if we only prove one, the other is surplusage. And the simplest way not to have to explain that to the jury is just to make it an or.
Mr. Hilliard, anything further?
I just think if you don't stick to what the language in the indictment is, it's going to create an issue back there in the jury room. That's my humble opinion, Judge.
All right. My inclination at this point is to have number 2 read cruel or excessive, but I'll take another look at it, but that's my inclination. Moving on then to voluntary intoxication, not a defense.
I don't think I requested that. So, I mean, I would object to it because I don't think anyone was raised that as a defense. But it's mine, I withdraw it. But
I believe that may have been yours. Mr. Reed?
I requested it because no jury instruction has ever been raised by the evidence more prominently than that instruction has been raised in this case. It's an accurate statement of the law, and the jury absolutely must hear that principle of law in this case.
All right. I'm going to include it. False report, we will make the changes there. He, she will make those pedantic changes. All right.
It does say, it says misdemeanor in there,
Oh,
Next one? Oh, I see it.
and I don't think the juries to know the distinction with respect to punishment.
okay.
That one's,
I'd suggest making that false report of a crime is when a person blah, 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 and then take off the guilty of a misdemeanor part.
That makes
Yeah.
sense.
Yep. Okay, so that charge goes in without the last phrase, is guilty of a misdemeanor. That comes out. Okay, making a false statement. Okay. Verdict generally. Unanimous verdict form. Court has no interest in case. Sympathy, responsibility for sentencing, deliberations, jury use of technology, retired to jury room. So going back through, page 3, grave suspicion, Mr. Hilliard would like that to remain. And I'm inclined to allow it to remain, mainly because there's not error, although I agree with you, it's not necessary. Witness attacked on page 6, as well as witness supported on page 6, have been withdrawn. Page 7, immunity or leniency granted witness, that will not be given. page 8, statements of defendant, that on page 8, really page 9, will be adjusted to reflect the difference between November 21st statement being in custody and the other statements were not in custody. Constitutional rights. We made a change there, did we not?
We did.
Okay.
If the statement was made while in custody, we think that you find that out.
Right. Defendant initiating further conversations, that will not be given. Conditions proceeding to consideration of statement will reflect only as to the November 21st, 2024 statement. Prior difficulties will be given over objection. Page 13, inferences will be corrected in terms of the spelling. Page 14, parties to a crime or parties to crime. The state very much wants that there. The defense does not want that there. Want it given. I'm going to take a look at that.
Allow me to revise my position. I don't very much want it there. I just,
Okay.
you know.
Thank you, Mr. Dean. So, parties to crime will not be given. And then aggravated assault with an offensive weapon.
Which page are you
I'm sorry, page 18. Will be, the last line, I believe, is changed to an offensive weapon is any object that causes death or serious bodily injury if used against someone. Also on page 18, cruelty to children in the first degree. The number 2 enumeration is going to be cruel or excessive. Otherwise, it remains the same. Voluntary intoxication will be given over objection. False report of a crime, also on page 19, will be given except the last part of that charge is guilty of a misdemeanor will be eliminated. And everything else, I believe, is pattern.
Can I ask a sort of a mechanical question?
Yeah.
When these charges are actually given to the jury, and assuming we have objections to make, I mean, according to statute, you know, we both get an opportunity to state on the record if we have any objections. Is the written charge that you actually give going to be part of the trial record?
Yes.
Okay.
And I plan for the written charge to go out with the jury.
The only reason I ask is I assumed it would be part of the record, but I wanted to be sure, because if it comes up on appeal, you know, I think you got to have the charge that was actually given, where you can reference, here's where it looks at. All right, well, here's where you can find it to see what we're talking about.
Okay. Anything else regarding the jury instructions?
Only one thing that I just noticed, Your Honor, and I could be misreading this, but on the bottom of page 19, making a false statement, I've tried to like diagram this sentence, and it appears to me it may not be a complete sentence, and I think it's probably because it was drafted from the statute, but I think it needs to say at the end something like, commits the offense of making a false statement. Or in the alternative, at the front end, it should say a person commits the offense of making a false statement when she knowingly, willfully, da-da-da-da-da.
That last construction makes sense to me.
Yes.
Yeah, that's
It's
fine.
more clear.
Okay, thank you for that note. Is there anything else that you're finding here in the jury instructions? And of course, take a look at it. If anything else comes up, we can we can discuss it and make changes as needed. But we're gonna have the jury charges. We believe it's gonna go out ready to go, and email you a copy for your review.
Can we get a copy tonight, maybe, Judge? And just, if we have any issues, just show up at 9:30 in the morning and deal with it then, if that's okay?
Did you just change the time?
No. I'll show up at 9:30. The jury's still back at 10.
No, we'll do 9 o'clock just in case.
Okay. All right. I don't care either way.
I like 9:32, but we're gonna do 9 o'clock.
I got to drop my wife at the airport, so I'm going to be here at 6. So it doesn't really matter to me. But I think if we have it tonight,
Yeah, you'll have it tonight, and if there's anything else that we need to attend to, we can. Okay?
works for me.
Okay, is there anything else tonight? Okay, we're in recess until 9 o'clock tomorrow.
Thank you, Judge.
Thank you. Everybody have a good night.
All right, so that's the end of day 8 in this trial. We also heard that the state and the defense rested today. We're expecting to have the jury return tomorrow at 10, with everyone else returning at 9 a.m. I just want to recap a bit of what we heard throughout the day. We heard final testimony in this trial from a medical examiner and as well as forensic examiners with the FBI. Here's a bit of the medical examiner's testimony on whether or not they were able to conclude the cause of death for Quentin Simon.
In a situation where the remains are primarily bones, would you be able to perform an autopsy?
No, not in the sense of obviously what I've just described to you as a complete autopsy on an individual who, let's say, is an intact body. So when there's only bones, there's going to be very limited ability to be able to provide enough information to say how a person has died.
And so we also heard again from Detective Lemons today. She took the stand again and they played out an interview that they had with Leilani the day she was arrested. And here's a bit of the questioning from the prosecution to Detective Lemons about that interview that they played out.
Was she asked at some point by you, I think we can all agree that something did happen.
Yes.
And did she nod her head yes in response to that?
Yes, she did.
Was she asked, do you think you may have killed him or something to that effect?
Yes.
And is it the case that she was just not able to give an answer to that or just didn't really say anything?
That's correct.
Was she, at some point, did Special Agent Solomon say, you harmed your child and hid him, or words to that effect?
Yes, she said that.
And is it fair to say that the defendant just did not affirmatively dispute that? She didn't say, no, I didn't?
She did not.
And we also saw Leilani Simon take the stand very briefly to deny testifying in this trial. Here's a bit of that with the judge asking her if she understood completely what she was doing.
To testify, you will be examined by your counsel and cross-examined by the assistant district attorneys in AUSA.
Yes, ma'am.
All right. Do you feel a need to have any additional time to consider whether or not you will testify?
I've been given plenty of time by my attorneys, notified weeks ago
All right.
about this.
Do do you need any time to talk with him in private about this?
No, ma'am.
And so, do you personally wish to testify or not?
I do not.
And so that was the one time we saw Leilani take the stand during this trial. We have our Shay Schrader outside the courthouse right now. Shay, you were in this courtroom 8 days of this trial. Tell us what is going through your mind now that both the defense and the state have rested.
I think I have the same questions in my mind that everybody else does at this point, which is what is the jury going to do? It's been pretty difficult to read the jury just because they've kept, their faces pretty neutral throughout it. And of course, haven't been chatting amongst each other's because they're not allowed to. I think the prosecution put up a very interesting case in the way that they were able to pick apart a lot of Leilani Simon's statements to police throughout the investigation. Again, categorically picking apart her story from day one. And today, one of the last things that they did is present evidence that the day Simon was arrested, she once again changed her story. And when she was asked point blank whether she had anything to do with killing Quentin or if she hurt him in some way, she did not deny it in her answer, really choosing not to answer at all at a certain point. But there's also the question of whether the lack of physical evidence is going to play into the jury's decision. It seems that if you pair up a lot of the circumstantial evidence along with the physical hard evidence that the prosecution have, there is a case to be made, but there's no telling what specific pieces of evidence the jury is going to place more weight on than the others. So again, I think I have the same questions and the same thoughts that most people do, which is I'm very interested to see what the jury is going to do. But before we see that, we have to go into closing statements, which of course could have a major impact as the prosecution and the defense are going to make their cases one last time and really try and put a bow on it before the jury goes into deliberations.
Yeah, and so for the last bit of testimony that we had today, we had those forensic examiners as well as the medical examiner. Anything of note for you from those testimonies? And we also saw Detective Marion Lemons take the stand again, talking about that final interview with Leilani Simon on the day she was arrested.
Yes, as for the forensic examiners, we did have a medical examiner from the GBI's lab testifying that she was not able to determine a cause of death from looking at the remains of Quentin's that were recovered in the landfill. And this is something that we were expecting. The prosecution was flat out about it in their opening statement, saying that the remains were in too poor of a condition to determine the cause of death. Now we had an expert witness testifying to that fact. I also found it interesting that the forensic toxicologist was not able to find traces of any drugs in Quentin's brain tissue that was recovered in that landfill. At one point, the defense seemed to insinuate that Quentin or the other children could have gotten into cocaine that was present near Leilani Simon and her boyfriend Daniel Youngkin's bed the night before Quentin was reported missing. But again, this testimony seeming to dispel that theory, although the defense did jump on that, the expert saying that the cocaine and other drugs were not detected, but not able to say that that means that they weren't present. Very specific terminology there. And then another interesting tidbit from that toxicologist saying that she was not able to test the samples from the pillowcase in Quentin's pack and play. Investigators believe that substance in the pack and play to be vomit, but this investigator saying that there wasn't a large enough sample size to determine what it really was. And then, of course, Marion Lemon's testimony again taking the stand, showing those statements that I've already discussed. Leilani Simon not denying in the 11th hour before she was arrested that she had something to do with Quentin's death and disappearance, and that may have been just some of the most compelling video of her that we have seen all trial.
Yeah. All right, Shay, anything else you want to add? We're on day 9 and we're expecting those closing statements as you mentioned tomorrow. Anything else you want to add about this trial?
Yeah, it's been a long 8 days of testimony. You can clearly see, that the prosecution and the defense put a lot of time into building up those cases. And again, I think I'm going to be very interested to see, as I'm sure a lot of our viewers are out there, what exactly the prosecution and the defense present in those closing statements, how they are going to kind of put a bow on some of the arguments that they've made through the cross-examination and examination of witnesses throughout this trial. And then ultimately, it'll be interesting to see, number one, just how long the jury takes to deliberate, but two, of course, what their verdict ends up being.
All right, Shay, thank you so much for taking time to recap the day. We know you'll be back in court tomorrow.
Thank you, Simone.
All right, everyone, make sure to tune in tomorrow morning. As you heard, court will start at 9. The jury will return at 10. So you can expect the live stream to start around 9:30. Once we have it, we take it right up to you guys. Thanks so much for joining us. You can get a full recap of today's happenings on the news at 7 when we break down the day with our Haley Bullen breaks down the day of court. You can also check our website for details on today's happenings as well. We have a story that includes a timeline that goes back before Quentin was even reported missing. Thanks for joining us. We'll see you tomorrow.